Good morning and welcome to everyone to this News-topia session. News-topia is the space of debate on legal topics. Today we will discuss about COVID-19 and multi-steps clauses. We will do that with Mr. Stefano Catelani. Welcome, Stefano, and thank you for participating to this session of News-topia. Mr. Catelani is an Italian lawyer who has worked for his entire life as in-house counsel both in Italy and in Geneva. He has spent the last part of his career as general counsel for DuPont Safety and Construction Business Unit within Europe, Middle East, and Africa region. And his most recent practice focused on compliance, general corporate and commercial law, merger and acquisitions, and of course, conflicts management and dispute settlement. Stefano is a member of the European Advisory Board of the New York-based Conflict Prevention and Resolution International Institute. He has recently formed his own firm in Geneva, Kalimala, and is serving as adjunct professor on international business law at Webster University. I have to say that I'm very happy about the participation of Mr. Catelani to this session, because I'm sure that his contribution will be outstanding to open the eye on a topic which, in my view at least, is of utmost importance now. We all know about the impact of the current COVID-19 outbreak, not only in sanitary terms, but also on the economy. There are many areas of business worldwide which are affected. Supply chains, as we will see shortly a bit more in detail, are in distress. And therefore, we believe that there is a high risk of an increase of caseload in the short, medium future. Therefore, for this reason, we believe that it makes absolutely sense to focus the attention and so to dedicate some time to reflect about the opportunities given by the alternative dispute resolutions mechanism. And for this reason, today we will in particular discuss about the multi-steps clauses, thanks to the contributions provided by Mr. Catelani. Stefano, welcome again. I would give the floor to start sharing some views according to your experience about the ADR and multi-steps clauses in particular.
Thank you. Well, first of all, good morning, everybody. Thank you very much, Andrea, for your nice introduction. I'm very happy to be here to participate to one of your sessions of the so-called News-topia talks. And I think, the topic you have chosen for this session is very timely. Not only because we are all living with the consequences of COVID-19, but also because that will have a clear impact on all commercial and business transactions, and more specifically on contracts. What has happened during the last few years, in my opinion, is very simple. Companies, especially large corporations, have obviously tried to internationalize and obviously also simplify supply chains. The international supply chains which have been created, therefore more, let's say, fragile in the sense that it's easier to create problems. The intent was very clear, was to try to maximize profitability, but at the same time, it has created some weaknesses. So because of COVID-19, there will clearly be many disruptions in various areas of businesses. Some companies will be unable to obtain the products or the raw materials which they need. There will be, force majeure events all the times. And therefore, what we need today, probably even more than ever, is the ability to prevent disputes, and when they arise, to resolve them quickly, rapidly, and efficiently. Hence, The need, I would say, to foster even more of the ADR culture, alternative dispute resolution mechanism culture. And also, I think a good opportunity also to reconsider the possibility to use multi-step clauses in contracts, because the intent of this clause is precisely that,
Sure.
to try to prevent conflicts, and when they arise, to solve them quickly.
Exactly. I mean, we are, of course, not talking about something new. Personally, I remember I've been studying for the first time ADR techniques more or less 20 years ago when I was attending a seminar held by the Chamber of Commerce of Florence, actually. But as you were saying, now I think that, and we both agree, seems that it makes absolutely sense to invest really time and share some thoughts on this. So let's see what really the multi-steps or multi-tiered clauses are. The multi-steps clauses are dispute resolution clauses, which set forth phased system, providing steps to be taken by parties to try to resolve differences or disputes, and which start with a certain number of alternative dispute resolution steps, which might be negotiation, mediation, dispute boards, but you will tell us a bit more in this respect. And in case of partial or total unsuccess of the steps agreed and taken by the parties will be, of course, free to file a claim before a court or to start an arbitration proceeding. So in this particular respect, according to your experience, which are the pros and cons of the multi-steps clauses, and so which are your suggestions in terms of drafting?
Yeah, well, first of all, you're right. I mean, there's really nothing new under the sun. I mean, these clauses have been around for a while. I'm not so sure they have been widely used, but I think that, the current situation should probably give more impetus to the introduction of these clauses in contracts. As you have already said, the clause will just require a step-by-step approach to the management of conflicts and disputes. The typical multi-step clause is actually a three-stage procedure. First of all, you start with negotiations conducted by senior managers. Then you move into mediation, and I would say normally mandatory mediation, in the sense that it should not be an option, it should be an obligation of the parties to do it. And finally, if neither works, you move into either arbitration or litigation. I would like to stress at least a couple of aspects. Negotiations seem to be an obvious thing. And it is true. I mean, a negotiation between the parties to try to settle a dispute or in general a disagreement is the obvious thing to do. But what I've seen in my previous experience is what I call the importance of changing players. Because the people who created the dispute, let's say middle level managers, are those who have, let's say, kind of negative feelings about it. You have in front of you, you have an enemy, and you want at any rate to try to not necessarily destroy her, but certainly you're not very, let's say, positive in the relationship. On the contrary, the introduction of people who are higher up in the organization and don't have all the negative feelings which have been generated by the tensions created between the parties during the time before the negotiations. They have a completely fresh look. They can completely change the dynamics in the discussion. And I've seen it a few times. That really works. It's like in a football team, when you change the players, you have a different game. Equally, when you move into mediation, in my opinion, it should be important to clearly state that there is an obligation to conduct mediation. So it's not a may, it's a shall, or because if you leave it as an option, parties might be tempted to skip it, while in my opinion, it's always beneficial to give it a try. And then if it doesn't work, of course, then you accept the consequences of all of that and you move into arbitration or litigation.
Yeah. So we understand the importance of very clear drafting. We understand the importance about the accurate words and terms to use to make sure that parties are clearly aware about the binding nature of the provision. We understand the importance to define clear time limits and procedures. And last but not least, the segregation between players. So the ones who have been disputing and the ones who have to sit around the table to try to solve the issues. I think that all these indications were extremely useful. But it's also true that it's well known that in the current situation, we are all experiencing a situation where there are bans, limitations in terms of mobility and in terms of possibilities to meet and so on, which affects, of course, the access to justice in respect of court proceedings. But these limitations, of course, apply also to the traditional or classical ADR. And for this reason, we think that it makes sense to start thinking to pass from the ADR to the ODR, where by ODR we mean the online dispute resolution, but not in the sense of artificial intelligence technologies, but on the contrary, we intend the technology assist mechanism. And in this respect, we are all, in one way or another, more used in this specific period to utilize the web tools. And so in this respect, it is absolutely important to try to make use of these web tools in the specific context of the ADR. Even in this case, we will have surely pros and cons. What's your view on this?
Well, I think you made a very good point. But first of all, I would like to go back for a moment to what you said about the importance of strict time limits and procedures, because it's obvious that when you're using these clauses which contemplate the various steps, it's essential to determine the duration and the time limit for each step, in order to avoid the risk that one of the two parties could be tempted to just adopt delay tactics and drag on forever.
Yes.
So it's extremely useful, actually I would say essential, to decide exactly when each phase should be finished and when one of the two parties has the right to move to the next phase. That's also extremely important in connection with the beginning of litigation of arbitration. In fact, I think there was a recent decision of a federal tribunal which looked into a case like that. One of the two parties had started arbitration without first going through a mediation phase. And I think, without going into many details, that the decision of a tribunal was you should go back to the previous phase, in my case mediation, and then you can start an arbitration process. So all these risks are clearly reduced if the clause outlines very clearly what are the time limits and the procedure. The other point you mentioned is exactly, what we are facing today. I mean, the fact that we can't move and we cannot travel and we cannot meet people freely is forcing us to use these online technologies more than ever, which is not that bad, because at the end of the day, we realize that very often in life it's just a question of habit, and now that we are forced to use them more frequently, we can see that it's not so difficult in the end, and that things can be done properly even using these technological means. We're just using Zoom today, and I'm doing my classes using WebEx. I mean, it works. It works, and it can be done. And I think it can be done also for mediation. I was talking to some of my colleagues recently. One of them was saying that she was able to do all my mediations online. Another one was saying that at least in 2 or 3 cases, the clients were showing a lot of resistance. So at the end of the day, it's not a technology problem. It's just a psychology problem.
Sure.
In the sense that obviously people prefer to meet personally. There is a chemistry, a possibility to, to convey feelings. The interactions are obviously better and stronger. And there is also a momentum, because when all the parties are closed into an hotel room, there is obviously a possibility to come to an agreement more easily than when you just do it at a distance. But despite the pros and cons, which exist, because, as I said, there are cons, but there are also pros, because it's obviously easier to agree on the schedules and to decide when to meet, because nobody has to travel. So there are pros and cons over time, but it's, in my opinion, this is a way to solve disputes, which is going to become more important in the future, I think also after this crisis. And it's doable, and it can be used whenever personal meetings are more difficult, as it is the case today.
Sure. I fully agree. I also believe that there will be a broader use of technologies to try to settle disputes via mediation or other alternative dispute resolutions mechanism via the online tools. It's also true, so I fully agree about the pros and cons. Maybe I will also mention that on the top of the logistic advantages and the fact that the online dispute resolutions have an impact under time and so cost point of view, it also provides access to justice or to mechanism of dispute resolutions to people with disabilities. This is also true. I mean, so I think there are different points, different issues which have to be considered. But in any case, may we like it or not, in the current situation, we are in some way obliged to find or to invest more than the past in this kind of tools. Also because we know that the model has worked, maybe not so much as you were rightly saying earlier, as could be expected some years ago, but in some cases it has worked. So why not invest more and more? So we are at the end of this today's talk. I thank you again, Stefano, for your contribution. Just to remember that this talk will be uploaded on the website www.news-topia.com. We, of course, remain at your disposal for any further clarification. I'm sure the same is for Mr. Catalani as well. Please stay safe, remain at home, and talk to you soon. Goodbye, and thank you again.
Thank you very much for this opportunity. And as you said, stay safe.